I'm John McNair, and today I am talking about a subject that is really important in estate planning, and that is planning for incapacity. People come to me for estate planning and they are laser focused on what happens when they die. That seems to be their only mission, is to make sure that good things happen when they pass away, and they are laser focused even more on wills, as if a will is the end-all and be-all of estate planning. It is not. There are other things that you need to deal with, and one of those things is making sure that if you're incapacitated, you don't end up in a guardianship, because guardianships are a bad thing for you and your family. They are time-consuming, they are expensive, they can be divisive in the family. There can be fights over who is going to be guardian. You don't want any of that. So, what are the things that you can do while you have capacity to make sure that when you don't have capacity, you are in good shape? Well, first, consider the disability planning documents. Number one is a power of attorney. Now, I met with a family yesterday, and they had a mixture of a good and a bad planning technique to deal with incapacity, in my opinion. One of the sons had the power of attorney for mom, and they did not want to look into any other ways to deal with incapacity, which is fine. A power of attorney is an absolute necessity when dealing with somebody who is incapacitated. The family I met with yesterday used another technique. That son was also a joint tenant with his mother on all of her financial accounts. What's the problem with that? Well, he had several siblings. And in this case, if he wasn't careful, if mom wasn't careful when they established that account, the bank probably established that account as a joint tenants with right of survivorship account. And what is that? That is an account that means that when one joint tenant dies, the other joint tenant automatically owns that account, lock, stock, and barrel. That person who died has given that account to that person. It doesn't matter what their will says. If they had a revocable trust, it doesn't matter what that revocable trust, it doesn't matter what any other planning document says. The account card with the bank trumps everything else. It controls. And in essence, she has disinherited all of her other children. Now, the family yesterday seemed to be fine with that. I'm assuming they think that that brother is going to share those assets with his siblings. I've seen other families where that doesn't happen. So another alternative is to have financial assets and real estate owned by a revocable trust. A revocable trust is a way to own your property where you don't own it. A trust that you control owns it. You and the trust are basically the same, but when you pass away, the trust continues, so theoretically you don't have to go through probate. But more importantly, my experience has been that institutions like banks, brokers, firms, and title companies are more comfortable dealing with with successor trustees under a trust rather than agents under a power of attorney. They just seem to really have a comfort level if there's a trust in place and they already know about the trust. So consider a revocable trust as an alternative to not an alternative, but an addition to the financial power of attorney, and more importantly, maybe a substitute instead of having a family member as a joint tenant on an account with the dangers that implies. With the revocable trust and a financial power of attorney, you've probably taken care of financial matters. I would highly recommend that you get a medical power of attorney to make sure that if you can't make medical decisions for yourself, you have a family member who can do that for you. One other thing about that, you need to have successors in both the financial power of attorney, the trust, the medical power of attorney, because what happens if the agent you name becomes incapacitated or dies before you, you need to make sure that you have multiple successors available to do that. Along with the medical power of attorney is important to have a separate HIPAA release. A HIPAA release gives your agent under the medical power of attorney access to your medical records. It will be very difficult for them to manage your medical affairs if they can't also access your medical records. They can't get a second opinion from another doctor because they can't request that the first doctor move the records over to the second doctor because they don't have access to the records. So it's a directive to physician in Texas. You may have heard it called a living will or an advance directive. It's the document that says if you are incapacitated and unable to communicate with your doctors and you're in a fatal condition and have no chance of recovery, do you want to be maintained on life support systems or do you not? Met with a family the other day, and the mother has early onset dementia, and they talked about and asked about a psychiatric or mental health power of attorney, which is also a separate document in Texas, and you might consider doing that. So that's a list of a few of the documents that you might consider when planning to try to avoid guardianships. A guardianship is something to be avoided. It is really, really bad. It's timely. It's time-consuming. It's expensive, and it can be divisive in the family. So, if you need help with any of these things, you can certainly call me. The initial consultation is free. The best way to get hold of me is to go to my website. There is a button you can click to book a call, and when you book a call, we'll talk about your situation, and if it looks like it warrants, we can have a full consultation. The consultation is free. I'll gather some information about you and your situation, and we will sit down and talk, and at the end of that talk, I can give you a flat fee quote as to how much that planning would cost.